Well, hello there, and welcome to the Disability Law Show. We're back for another week. Glad to hopefully have you along for the entire show. We got lots to cover. John Scholes here, Sivan Tumarkin there as well. Disability lawyer, of course, at disabilityrights.ca. Reach out anytime to Sivan and his team. That number 1-855-821-5900. Help at disabilityrights.ca. We'll go through that. Some emails on the show today. We always have a main topic in the second segment of the show. This week it is mental health and long-term disability claims in Canada. So that's all ahead, so stay with us. But we always kick it off, Sivan, with a week that was. Case of the day, what do you got going on for this show?
John, I want to start off with an interesting call that I had this week. It was from a 43-year-old woman. She's a mother of three. She's from northern BC. She's a marketing executive. She's been on long-term disability for about a year or so for psychological issues, as well as for various back pains and other types of issues that she's experienced ever since she had her third child. So it's tied to the complications that she had with her third child. In any event, she's been on long-term disability now for a year, on and off dealing with her adjuster at the insurance company. And the insurance company asked her to do something which they asked often people to do who are on long-term disability, which is to see one of their assessors. It's called an IME, Independent Medical Examination. Except, of course, as we've talked before, this is anything but independent, since the insurance company is the one who selects the assessor. They pay for the assessor. They're expecting something that's going to help the insurance company, not the individual. In any event, the interesting thing about this claim is that after the assessment was done, and it was done by an orthopedic surgeon, I'll get to this in a moment, the orthopod said that physically she was okay. There were no restrictions for her as a marketing executive. There's no issues for her to do her job, whether it's to go into the office, whether it's to work from home, whatever it is, she can do her job, okay? Of course, as I mentioned at the beginning, she's off on LTD, not only because of those back issues and other physical issues, but psychological issues, again, all associated with what happened with the last pregnancy, with the last child. Regardless, the insurance company, on the basis of this IME, on the basis of this assessment, decided to cut off her benefits, saying, you are cleared to go back to work. Our assessor said you can go back. And of course, she appeals that decision, as many people do when they're denied or cut off long-term disability. And so now she's waiting for that decision from the insurance company, but her adjuster said, don't hold your breath. You're likely not going to get approved. You can imagine that's just exacerbating her condition. You can imagine that the entire family is in stress mode. Look, she was making good money. Her husband also works, but her salary was higher. They got 3 kids. It's BC. It's expensive. So she called me after seeing the show and talking to a few people who we've been able to help. And here's what I explained to her. Look, the fact that you are on LTD, the fact that you have a psychologist, the fact that you have other treating providers, you have a family doctor, chronic pain doctor, a variety of other doctors that have confirmed that you're disabled. The insurance company is saying that they've cleared you to go back to work, or their doctor has, but on the physical side of things, not the psychological side of things, that means that the insurance company is wrong for stopping your benefits, because clearly you're not off work only because of the physicality of the situation. Now, this may seem like common sense to you and me and our viewers, but to the insurance companies, it's not. And why is it not? It could be that the adjuster who's looking at the file is simply looking at them thinking, well, no, she's been cleared to go back to work, so I've done my job, this person can go back to work, cut off benefits. Or it could be that the insurance company, as having been in this industry for many years, look at the way insurance companies do business, there's intentionality, there's intention there. And I think that this insurance company, that this adjuster likely understands that getting clearance to go back to work after an orthopedic assessment, when you have psychological issues involved, that's not the end of the analysis. But I think that this adjuster understands as well, because it's a senior adjuster, that the majority of people out there simply give up on their claims. If the insurance company says, we're not paying you anymore, these individuals just give up. They may appeal the decision, just like this lady did, but oftentimes they just give up. So what I told her is, do not give up, but you don't have to fight. Let me fight. Let me and my team take this on. And I bet you, John, that I can get this reversed, either reversed with the insurance company within a matter of days or weeks, or I can get them to the table to negotiate a fair settlement for this lady and her family. And that's something that I want to mention to people out there if you're listening. You have to understand that these insurance companies, they may look big, they have billions of dollars in profits and revenues, but at the end of the day, they want to make money, and they don't make money by fighting these kinds of claims they know they're going to lose. And I'm saying this, by the way, John, as somebody who used to work for insurance companies. Right. As soon as we get involved, and they know us, these insurance companies, we deal with them every day. Every insurance company that deals with long-term disability in Canada knows us, knows me, my firm, the lawyers in my firm. They understand that we will represent someone, we're going to go the whole way. Like, we're not giving up. We're taking legitimate claims only. So there's a reputational element, plus we have the resources to take this all the way. We can take the fight to them. So they're going to come and they're going to resolve this. And there's a reason why when we get involved, sometimes very quickly the insurance company reverses course literally when they get the letter from us saying that we represent the person. So I told this lady all the stuff. I explained to her her legal rights. We spent about an hour and a half on the phone. Her husband joined in afterwards. And again, to anybody out there, if you have any questions, you are dealing with these kinds of issues or any issues dealing with short-term or long-term disability, or you know someone who is, feel free to reach out. We'll speak to you for free. Won't cost a cent. We'll explain to you your rights and explain why it is that you have options that you didn't think you did, and why this insurance company that's bullying you is not as strong or as big as you think that they are.
Why do you think that the insurance company during the IME did not include the mental component as part of their, their service? They should look at that part as well, right? Maybe she's not mentally ready to go back to work.
Excellent question.
Right?
Excellent question. Your guess is as good as mine, but let me give you two possibilities that just come to mind. Number one, they figured that it would be easier to get her cleared by an orthopod. By the way, orthopedic surgeons have tremendous respect for them, but typically they look at things in a very kind of black and white-ish manner. They'll say, look, I think this person can move this way, can move that way. I'm not saying anything on the x-ray, blah, blah, blah. I think objectively speaking, medically speaking, there's nothing preventing this person from going back to work, particularly, again, when it's a sedentary type job. So I think that's one aspect of it, that they're going to get a more favorable report. Psychological, psychiatric type reports are a bit more complex because, again, you can't see these things on an x-ray. So insurance companies sometimes get burned with these kinds of IMEs. So that's one possibility. Another possibility is that it's just too expensive to get two assessors.
Right.
Maybe one will do. Why do I have to pay another $6-7 grand to an assessor, because it costs a lot of money to get an assessment? Maybe I can just get this person off claim just by having this orthopedic surgeon provide the report. If need be, maybe we'll do one down the road. But for now, why spend double the money? So there could be that reason as well. Or it could be, listen, maybe the adjuster just missed it. I have situations where insurance companies actually get incorrect assessments. I'm dealing with one for a friend of mine right now who has psychological issues, has heart issues, etc. And he went through a whole bunch of assessments, but one of the assessments they were missing. And again, that's an Achilles heel for them. So my point is, it could be a whole bunch of reasons, but it doesn't matter because I recognize it. I know now that's a weakness. I explained this to this lady, and it makes sense when I explain it, right? But when the insurance company tells you, our doctor says you can go back to work, you think, well, I have no options. I have no choice. Oh, yeah, you do. Yeah, you do.
That'd be interesting to get the percentage of people who say just what you said there. Oh, geez, okay, well, they said I got to go back, I guess, and they're shaking off claim and they don't bother calling you. Obviously, it's successful for them. That's why they do it.
100%. And if people don't give up when they're cut off or denied, I bet you many of them give up when they denied the appeal and then a second appeal. These are all processes, in my view, designed to frustrate individuals who are already in a very precarious position. They're battling with mental issues, they're battling with physical issues, there is economic stress at home. You know what I mean? You've no idea how many times I've spoken to people who called me, not because they wanted to, they were ready to give up. It's because a loved one or a friend saw me on TV, heard me, maybe dealt with me and my firm and said, you have to at least talk to these guys. No. Don't give up before talking to them. It'll cost you nothing. And so people do it, and when they do it, by the way, incidentally, and we talk about this all the time, one of the things people take out of these conversations they have with me is not even the fact that they have rights. Is the fact that I'm telling them, I'll deal with the insurance company. You don't even have to do anything at this point.
That's the best part.
Let me deal with the insurance. Let me go after them, make their life hard, make sure that you get the money you're owed. Right. And that's what people hear. They hear, I don't have to deal with this adjuster anymore. I don't have to get those phone calls, those emails. Those in and of themselves are such stressful moments.
For sure.
Yeah.
PocketDisabilityLawyer.ca. What is it? Tell me about it.
So that's a website we created a long time ago, which has been used widely across the country. Look, some people, for whatever reason, feel intimidated. They don't want to call. I'm a nice guy. We got nice people at the firm, but they want to go online. They want to go on Google, maybe AI, and get some answers. The problem is, you may get the wrong answer. You may get an incorrect answer. You may get an outdated answer. You may land on a web page from a different province or a different state or a different country or whatever. PocketDisabilityLawyer.ca we created because it's relevant to Canadians. It's anonymous. It allows you to get your questions answered that are relevant to you, whether it's short-term or long-term disability, whether you've been denied, or maybe the insurance company is asking you to go to an IME, or maybe they're asking you different things. You want to know what your rights are, but you don't want to call anybody. You go to that. It's anonymous. Again, it's free. It's quick. You'll get an initial starting point. You'll get information that's relevant to your case. And then after that, if you want to reach out to us, by all means you can, but at least it's a starting point and it's free.
We have got time before break to slip in a viewer question. It's actually a phone question from one of our radio shows. Let's get to that, Sivan, and see what they got to say.
I worked for a company for 4 years. I went on short-term disability. At the end of the short-term disability, they denied long-term disability, even though I'm still in a lot of pain and unable to work regularly. Now I've got a severance letter. They basically disbanded the department I worked in.
I can hear the stress already.
Yeah, for sure. I mean, look, he's getting it from both sides. Right. The insurance company that's just denied LTD, and then he's getting severance, right? A severance letter. So look, we're dealing now with an insurance issue, disability issue, and an employment matter.
Yep.
And you can imagine people find themselves between a rock and a hard place. And one of the unique things about our law firm, and we help people across the country, is that we deal with both employment and disability matters. Now, this individual here, clearly he was accepted for short-term disability, okay? The test for getting short-term disability is the same as for long-term disability. You have to show that you are disabled from doing your job, your occupation. So why is it that he was denied LTD when he was accepted for STD? I don't know what the answer is. I have to look at the documentation. I will tell you that people take for granted the fact that if they're approved for short-term disability, that they'll be approved for long-term. You can't take that for granted because, number one, whoever's paying you may be different. It could be that your short-term is paid by your employer. It could be that your long-term is paid by the insurance company. It could be that there are two insurance companies dealing with short-term and long-term. It could be the adjusters are different. Most likely they are. They're interpreting the documents differently. But my view is this. If the documents that this gentleman showed to get short-term disability, which typically is about 3 to 6 months worth of benefits, if they were sufficient for him to get short-term disability and his condition hasn't changed, he should be approved for long-term disability. So I can help him with that. I can definitely deal with the case, make sure that he gets the long-term disability he needs. But at the same time, he received a severance letter from his employer. Well, as you know, John, you've done enough shows with my partner Lior and other lawyers in my firm who do employment law. If you let go of someone on disability, that's a human rights violation. So now we are dealing not only with severance, potentially, and the LTD, but maybe with human rights damages.
Big one.
And again, I would want them to chime in here because I think this gentleman needs advice on the severance. But you also have to understand that LTD, disability, and employment law interact. So you may have a situation where you may get severance from your employer only for the insurance company to say, well, we get a credit for that. So you really don't gain anything. But there's ways around it. There's ways of figuring this out. And why is this important? Because many people out there don't understand that if they get a severance or if they get LTD, there is an interaction with employment and insurance. And so they'll go to a strictly employment lawyer, not understanding that they may get a good result, but it may come out the other side and vice versa. And the nice thing about our firm is we have lawyers who do hybrid law. Right. They are essentially experts in employment law and in insurance law and disability law. So you're not going to have that situation where something falls through the cracks. So this gentleman here, I think we can definitely help him both with his severance issue, with the employment issue, and with the insurance issue. We can make sure that he gets the money he deserves.
We will take a short break, and on the other side, we get into our main topic, mental health and long-term disability claims in Canada. That is coming up on the Disability Law Show, so stay with us. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. Alrighty, welcome back. Disability Law Show continues. John Scholes here, Sivan Tumarkin, always reachable. As you know, consultation, by the way, won't cost you a penny. Just pick up the phone, write that email, 1-855-821-5900, help@disabilityrights.ca. It is main topic time, and as I mentioned just before the break a moment ago, mental health and long-term disability claims in Canada. Pertinent information. Number one, Sivan, depression, anxiety, PTSD, along with many mental health conditions, can qualify for LTD, long-term disability benefits in Canada. Some may not know that.
Yeah, John, one of the things that people are often confused about, and I get these questions all the time, and they're legitimate questions, is does my illness, does my condition qualify me for long-term disability? And maybe they've heard through the grapevine that it doesn't. Maybe their doctor says it doesn't. Maybe somebody at HR at work said it doesn't. It's irrelevant what these individuals are saying. What's relevant is what is in your policy. Remember, if you have long-term disability coverage, insurance coverage, it's like house insurance, travel insurance, car insurance. There is a policy. That policy states when can you apply and get long-term disability and when you can't. I can tell you unequivocally that the vast majority of these policies are very, very broad. What does that mean? It means that they have a definition that says, or a clause that says that if you are totally disabled, I'll get to the totally in a second, totally disabled from performing the essential duties, the functions of your own occupation, then you will qualify for long-term disability. There's a few other provisions that are relevant, but that's the key thing. Now, they say total disability, again, total, doesn't mean you're catatonic, doesn't mean that you are bedridden. No, it doesn't, none of that. All it means is that you can't do your job. You cannot do your job. You can't do the main aspects of your job. That's it. So, if you are really depressed, John, you can't get out of bed and you're fatigued because you're not sleeping, whatever it is, you tell me in what profession can you properly function in order to fulfill your job? A school teacher, an engineer, a radio show host, a TV show host.
Pilot, doesn't matter.
A pilot. If you are depressed, if you have anxiety, tremendous anxiety, if you have some kind of a phobia that prevents you from interacting with any type of condition, I don't care what it is, that prevents you from performing the essential aspects, tasks of your employment, will qualify you. In the unlikely event that the insurance company says otherwise, I want to see the policy. Right. Because I bet you the adjuster probably hasn't read it correctly. I've seen people be on LTD because of depression, because of anxiety, because of PTSD, because of phobias, because of any number of psychological conditions. So don't let anybody tell you that just because it's psychological, and I say just because, which is stupid to say, you will qualify if you cannot work because of that condition.
Number two, mental health disability claims are often denied due to insufficient medical evidence. How many times have we heard this?
So we've heard it a lot, but it is important. So I want to be fair to insurance companies. Yep. Okay? You can't go to an insurance company and says, I am depressed, give me long-term disability, pay me 65% of my annual income. They're going to say, rightly so, show us proof. Right. Show us medical documentation. And what does that mean, medical documentation? Well, you need to get something from whoever's treating you. Could be a family doctor, walking doctor, it could be a psychotherapist, psychologist, psychiatrist, whatever. You need to have something that shows from a professional that's treating you that you are undergoing treatments, that you are experiencing these symptoms. Maybe there is no diagnosis attached. Okay? Generally there is, but maybe there isn't. But you need to have some kind of medical evidence, some reports, some notes from the doctors that you can show the insurance company that, in fact, no, this is true. It's not just me saying it. Look, I am getting, help. If you do that, then the insurance company has to accept it. Now, sometimes they don't. Sometimes they say, oh, it's insufficient. You've given them a binder that's 5 inches thick, and they still say, it's not sufficient. Come on. In those cases, I want to get involved. I want to talk to the insurance company. You'll see how quickly they reverse their position. So a lot of times, that's how they frustrate people. Yeah. They tell you there's insufficient medical documents, but really there are.
Well, you mentioned all the paper, and that is consistent treatment records can strengthen a mental health disability claim, right?
You have to show, and this is key as well, because some people, they revert to their home, they revert inwardly, and they say, I don't want to deal with anybody. I don't want to get any more treatments. I'm done. Here's the problem. Your policy of insurance requires you to mitigate. That means that you have to try and get better. That is in the policy, most likely, but that is also an aspect of our law in Canada. It's called common law. There is a duty on an individual to try and get better. And it's common sense, frankly. So you do need to make sure that you do go to your doctors, to your treatment providers. You're following some kind of a plan. You can work with whoever's treating you to make sure the plan is good for you. But you have to show you're trying to get better. If you don't do that, the insurance company may take the position that you are in breach of the policy because you have not tried to get better. So you have to do it.
That will cover the main topic. We're going to take a short break, and on the other side, we'll get to another phone call from a viewer from one of our radio shows, or listener for that matter, and continue with much more of the Disability Law Show. We're coming right back.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
Okay, we are back. Thank you so much for sticking around to the Disability Law Show. We'll continue with more. First, I always want to give out the contact information to reach out to Sivan and his team anytime. Phone number 1-855-821-5900. Consultation free of charge. Nothing to make you hesitate to call that number anytime. And if you want to back it up with the email, that's always possible. help@disabilityrights.ca. One of our long-running radio shows. Let's get to a listener call that came in a short time ago. Sivan, so listen up. Here we go.
My partner's applied for LTD, and that was quite a while ago. They're taking a long time. So they just issued recently something called a without prejudice payment, indicating that, yeah, this is taking a while, and so here's some money. Are they admitting something, or is there an actual limit processing LTD because it has been a while? And should we accept it?
Never had that question before. Wow.
No, except that, interestingly enough, I just had that question from a gentleman who was asking about travel insurance because he was injured when he was visiting parents in Europe.
Right.
And the insurance company there said, we're going to pay for the medevac and to get you back to Canada and all that, but it's without prejudice because we're still looking into your claim. So he was asking me what to do with that. Same idea. So here's what that means. Insurance companies sometimes, they understand they have obligations towards you because you are the insured person. It's a very special obligation. They don't want to be accused of delaying. They don't want to be accused of being unfair. So what they'll say is, we haven't had enough time to go through all the processes internally that we need to go through, so we're going to start making payments. We're going to start doing something, but it's without prejudice, meaning that down the road we may decide that, in fact, we don't need to actually make those payments. So the fact that we're paying you now doesn't mean that we've made a final decision on the issue of whether you're owed that, okay? What's happening here is that this person is asking, should they accept this payment? Well, the answer is yes, accept the payment. Technically, it's without prejudice, which means the insurance company can come back saying, well, we didn't really need to pay, but we did out of good faith, but we're still looking in the claim. And they're correct, except that optically, it actually looks good that they made that payment. And it looks bad if down the road they change position. Okay? Notwithstanding the legalities, optically, it's better for the individual to accept this payment at this point.
Oh, wow.
Number one. Number two, and this is important here, there's a question here which I get quite often. They are looking into this application. This person applied for disability, LTD. Many people call me and say, look, I'm waiting now for a few weeks, for a month, for 2 months. What's reasonable? When am I supposed to get the decision? Remember, people have bills to pay. Mm-hmm. And so what I tell them is that there is no fast and hard rule. Typically, you get a decision within a matter of weeks. Sometimes the insurance company says, we don't have enough information. Please get us this or that. Obviously, you should get them this or that as much as you can, assuming these are legitimate requests. Yep. But look, until they approve your claim, until they've done that, it is effectively a denial, if you think about it. Right. They may disagree with me. Insurance company may say, well, it's not a denial. It's us saying that, in fact, we haven't made the decision. But that's not exactly correct, because by not paying you, deciding to pay you, they haven't rendered the decision. Right. So what I tell people is this. Look, if you've waited for about a month, tell the insurance company that they have until the following week. Give them another week and say, if in writing, email them this, the adjuster, and say, if by the end of next week, I don't get a response, yay or nay, I will take that as a denial. Put that in writing. And then if they don't respond to you within that week, come to me. Right. Because then I will take the position that that's a denial, because you've told them that. So they can't string you along forever, and that's what they do sometimes. Sometimes I think it's intentional, Sometimes I don't think it's intentional, I just think that they're taking their sweet time, which they should not. So very, very important to understand, they cannot simply drag the process forever. They have to give you a decision. If you feel that enough time has passed, give them a deadline and tell them, if I don't get an answer by that deadline, give them at least a week. Yep. Then I will take that as a denial. And if that's what happens, you give me a call immediately.
Give you a real quick email here. We got a couple minutes to get it done. I've been on LTD for almost 3 years now to complete complex PTSD and anxiety. My income prior to being on leave was a combination of base salary and commission. It was a senior sales role. Lately, my insurer has mentioned the possibility of finding a comparable position. I'm nervous about being forced into a new job, which I'm not properly compensated for. What do you think?
All right, John, what word comes to mind here?
Lior.
Okay, yeah. For the employment side, yes. But on the disability side, we've talked about this before. When the insurance company is trying to get you off claim and they say, look, you can do some other job. This guy's been here on LTD for over 3 years. So he's now in the any occupation stage. So they have to find him a job for which he's suited for by training, education, or experience where he can make commensurate income. Which is anywhere from, I would say, 60 to 70%, let's say 65%,
sure,
approximately, of your pre-disability income. That's kind of the litmus test. What does that mean? It means, look, if you can find a job at that point in time where you can earn what you're getting from your LTD insurer, essentially, they may have an argument. I'm not saying it's a straight-cut argument. It's possible that they can't cut you off at that point, but they may have an argument there. So I understand what Jack's saying here. I mean, he was making a lot of money. We don't know how much, but I'm taking from this that it's a lot of money. He cannot be forced off claim. And I would suggest that he give me a call so I can get more information. I can give him a lot more detail, a lot more information to help him understand what his legal rights are. But this happens quite often, John. People need to understand insurance companies cannot just cut you off without a good reason.
PTSD and mental, again.
One of those huge.
Things. It's one of those things.
He's owed the money, man. He's owed the money.
You'll be getting the phone call for sure.
Yep.
Thank you, Jack. Appreciate that email. Keep on watching and listening to our radio shows as well. You'll want to reach out to Sivan and his team. You can anytime. That phone number, 1-855-821-5900. It's help@disabilityrights.ca. And for anything else you need to learn or contact information, simply disabilityrights.ca is the website you can trust. Thank you so much for tuning in, and we will catch you next time right here on the Disability Law Show. Enjoy the rest of your time.